Are you pulling your hair out trying to figure out how to negotiate with your ex? Or are you even too afraid to make an offer because you're worried if you do, it's going to explode? In this episode, Mum and I are going to walk you through some strategic steps on how to negotiate at every stage during your divorce or de facto separation journey, from the early talks, mediation, to court offers and last-minute settlements at the court door. Whether you've just started out or you're in the process of going to court, we're going to show you how to approach negotiation like a pro. Welcome, Mum.
Hello, Laura. Hello, everyone.
Now, before we get started, we're just going to point out that Mum is not your lawyer. I am not a lawyer. And so obviously, when you're listening to this episode, just be reminded it's just a general discussion and you must always get your own legal advice before you make any decisions or actions. All right, let's get into it.
Hello, I'm Laura, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
Now, Mum, today we're going to be covering how to repackage your offers so it's more appealing to your ex. We're going to be talking about using the right language, about percentages and how to speak it. We're also going to talk about the personalities that you need to handle and what you need to consider, and making strategic use of legal tools like Calderbank offers. And also at the end, we're going to do 10 do's and 10 don'ts when it comes to negotiating. So hopefully if you're listening today, something's going to hit you and you're going to come out of this episode knowing, okay, I need to change this, or I need to consider that, or I've got to go talk to my lawyer about this. So let's get into it. I guess negotiations, it's the main point of divorce. I guess it's the whole point.
Yes.
Why do you need a negotiation strategy when you're going through divorce?
Well, it's the only thing that's going to save you from having to go to court and have some person you don't know make decisions for you and your family. And that's one downside of going to court. So you don't want to go to court. And also the costs and the uncertainty and the delay. So negotiations are where it's at, really, for everyone going through divorce.
Okay.
And anyway, you have to start with negotiations before you can go to court.
So why does that, because we're going to be talking about how to negotiate before, around mediation and then also around court. Why does the negotiation strategy change based on what part of the process you're up to?
Yeah, I guess you try to keep it amicable and hope against hope that you're going to get a friendly agreement in the early stages, or at least a respectful agreement. Once you're into mediation, I think that means that someone isn't agreeing with someone else. So you may have to be a little firmer, perhaps back up why you want a certain percentage or what your arrangements for the children are. And then when you're in court, it's really a thing of weighing up what your chances are of getting what you want when you go to trial and the costs of that.
And pointing it out to them, I guess. Yeah.
To them and to yourself. I
Okay.
think it factors in when if they give you an offer and you think how much it's going to cost you to go to court. You make a commercial decision sometimes.
All right. So let's talk about the early stages, right?
Okay.
So this is the part where people haven't even probably told some of their family and friends. It's not particularly well known that they're splitting. And there are many amicable people that we've heard of who are able to do the negotiations themselves, like we talk about using our course and just getting it sorted, seeing the lawyer just twice. What strategies do people need to be thinking about when negotiating an offer with their ex? And I think you already touched on a little bit, and that is trying to keep it amicable. So what kind of things should people be thinking about and doing in these early stages?
Well, first of all, want to make the point that if you need to reach a rough agreement or a verbal agreement on something in order to get out safely, safety is important. You can always go back later on and say, no, look, I was under duress at the time.
I'll put the proviso, Mum means that you don't sign anything official. She's saying you can say yes to a verbal agreement and then get the heck out of there and change your mind afterwards.
Yes.
Okay.
You're right. You're right.
Yeah. But if you sign something, you are kind of stuck with it.
You can be stuck as long as but it might just be a piece of paper.
True.
So in those early stages, you really want to see how much common ground you've got. And you're already stressed. It doesn't matter how long you've been thinking about leaving, how pleased you are you're getting out, how relieved you are. You're always, it's a highly emotional time. And so each of you may well be very touchy, and having a respectful discussion may seem impossible, but do the best you can. It depends on, like Laura said, like you said, darling, the people who are able to reach agreement between themselves and they do the course and move on, they almost never see the lawyers, will never see the lawyers more than once. But those early stages, it's tricky.
So don't rush it. Don't go in there and just go, okay, let's do 50-50 or start throwing percentages at people. That's not what you really should be doing in the early stages. You should be really just trying to get your head around first, what am I entitled to? What do I want to be asking for? Because if you don't do that work and you start negotiating with your ex before you've even done that work, you're going to end up negotiating something you actually don't want.
I think the key words for this stage of negotiation are let's. Let's talk about the kids. Let's think about who stays in the house. Let's look at what we're likely to get. And of course, my personal favourites, which may come at you, let's not get lawyers involved. Let's not touch our supers. Those are also things that people throw into
And
the
they're
mix.
bad ones.
Sometimes they are bad, yes.
So I guess, in the early stages, don't rush it. Don't lock anything concrete straight away. We have heard of some people with kids stuff in particular. In the first 2-3 weeks negotiating kids stuff, you might not know that it's not going to work. You might be trying something, like we hear a lot of people, they try to do 50-50 and then the kids are starting to not cope, but they've locked it in. Now they can't undo it. So, when you're negotiating, try and just negotiate temporary stuff, temporary plans or trials of things to see what's going to work, if it's safe to do.
A way to envisage it is to think that you're like kind of two Post-it notes stuck together as a couple. You've been doing things together. And it takes time to begin to peel those things away so that you can truly separate. So the things that you can bear to think about in those early couple of weeks is probably closer to what you were doing when you were married together than what would suit you in the long term. So give yourself time. It's a process.
Okay.
And so those very early stages are quite different.
Right. I guess later on, people are negotiating. They may be sitting down, saying at the coffee table, saying this is what I think, or this is what I think, or they're sending emails to each other saying this is what I think, this is what I think. Then people get stuck. And this is the negotiation stuff that when it starts to get a little bit more, we need to be thinking about this carefully.
Yes.
So people get stuck and their next step is to go to mediation. And mediation in itself is a negotiation strategy. But Mum, one of the things that we talk about a fair bit is trying to figure out how you can, and I said window dressing and you've come up with another name, but you used to be a window dresser, so I like this idea.
I did used to be a window dresser.
Window dressing your offer to make it more appealing to your ex without actually changing the essence of the offer, without actually changing what the outcome is. Now, is that like marketing?
It's like parenting.
Right.
I think it's more like parenting.
Right.
Okay. So if you've got a proposal to put to the other side and you know the things that they are most worried about, for instance, the house or the property or the business, whatever, in the packaging or window dressing of your offer, I would put that as the first thing so that as they read that, they go, oh, okay, that's all right.
That's taken care of.
That's right. And then they can be in a slightly calmer frame of mind to look at the other proposals. And, and we do it with kids. Yes, you can play on your device after you have a bath, that sort of thing. Do it that way. They calm down.
So when you've got a proposal in front of you or an offer and you're the one who really wants to keep the house and you're tensing up because you don't want to read it and you read it and then the offer of the house is like the second last line on a 50-page document, you're not going to pay attention to anything else at all.
No.
So you're saying to try and put some of the stuff at the top that you know that they're most worried about that might calm them down and alleviate some of their fears. Soften them.
That's right.
Soften them up.
Yes. But so just give them some ease because you're right, Rose. You scan through and then you find the thing you want and you've ignored all of the rest of it. Or you might have read the rest of it thinking that you weren't going to get the house or the business, which would just make you very angry with the whole thing. So, I mean, I take a lot of care, or I used to take a lot of care, even in the subject line of an email. You know, if you've ever had emails from, like, probably emails from your ex in those early stages make you tense anyway. So there's a way to sort of soften that and,
Okay.
you know, yeah.
Like, then I guess the other way to window dress your offer is to think of it as a whole dollar amount. Like put all your
Yes.
assets in. So your super, your house, your blah, blah, blah. Everything's just a dollar amount. And
Yes.
then figuring out then how to say, well, you can get that much of the super and this much of that. So again, Mum, can you explain how you go around that part of things?
I think what you're saying is don't get into percentages.
Okay.
That's how I explain it. 3-year-olds understand fair, right? What's fair, what's not fair. And 50-50 sounds fair to everybody, okay? But so 60-40 sounds unfair, and 70-30 sounds even worse. So don't go down that path. Don't crystallise those numbers. Perhaps put dot points of the things they're keeping and dot points of the things you want to keep. And those things can be like, you know, almost the no-brainer parts. And then the cash adjustment between you both then remains the only debate.
Right.
Okay?
Right.
And you could put a number that in your mind makes everything 50-50. They could put a different number, but still in their mind it's 50-50, depending on what values they put on things. So I don't like to rush to doing sums too early. Don't use numbers much. Don't put too many values in.
So we talk about, we've done a whole episode on the pitfalls of percentage negotiations early on, because like you said, Mum, if you sit down with your ex and you say, all right, let's agree to 50-50, then you're saying, all right, we've agreed on that, but 50-50 of what? And then we get into this big fight over not the percentages, but what the values of everything are, because if the house is worth 2 million, but they think it's worth 3 million, when you do the 50-50 split, you might not be able to afford to keep the house, you know. So there's all these things. So it's a really good idea to step away from percentages and don't raise them at all until the end if you have to, because you in your head will know what percentage you're entitled to, but you don't have to say it to the other side. Because I've heard of people going through divorce recently where they agreed with their ex to do a certain percentage, but the split to them was that percentage, but to their ex, that was a different percentage, but they were both happy.
Yes, and we often do that in court.
Okay.
You'll notice when handing up consent orders, for instance, it wasn't uncommon or isn't uncommon for one lawyer to say, Your Honour, on my client's figures, this is a 70-30 split, but on my friend's figure, it's more like a 60-40 split. The court accepts that. What you do if you start doing percentages first is you're not just going to have to talk about the value of the house and the big stuff. I've seen matters where every little thing suddenly becomes a bone of contention. What's your handbag collection worth? 2 coffee tables matching, one that she's getting is X dollars, one that the other person's getting is Y dollars. Like, you just open up the arguments. So you're right. So keep that bit to yourself. And when you get to that final number at the bottom that you want to talk about, right, that may end up being the only thing you're arguing over. And don't forget, it's not all cash. It's cash and super. So it's kind of like 4-dimensional. You've got cash, super, the slide there, and then the how much going in the horizontal. So, so don't get into individual items early on. I like dot points. I don't even, in those very early stages, coming up to mediation, there's a temptation to number things, and I don't even do that. I put dots.
Okay.
I don't want to take their mind to maths.
Right. Okay. All right. So stay away from numbers, stay away from maths if you can. All right. The other thing in negotiating with them during the mediation phase and stuff, which you've mentioned before, is try and use their language, use their framing, and use their terminologies instead of your own, because sometimes that can make them feel like, oh, this is my idea or this is my agreement.
Yes, you're right. And I like to, if they've got a certain way of setting things out, I just follow that. It calms them down. If you've got two people who insist on their own sort of way of looking at things, sometimes it takes a lawyer to look at it and go, you know what, you're actually saying the same thing. It's just slightly different. So take away those sort of barriers to understanding.
And that'll save you at least, I don't know, $1,000 in lawyer fights just over that. And we do talk about, Mum, how hard it is for people who have been in a manipulative, controlling relationship or a high conflict, and they're just freaking done. They don't want to let this person bully their way to one more inch.
Not an inch.
But if it's using their wording and terminology to get to the end of this and to get as far away from them as possible for the rest of your life, it might be worth it.
It's what you've been doing the whole relationship.
Yeah.
Okay? You know how to handle your ex. It's not dishonest. And we agonised over that, didn't we, Laura? If we were teaching or talking to people about being manipulative and controlling. It's not. It's just working with the person's personality and your own to get you to yes and save everybody from
Sometimes for a cheaper divorce or de facto separation, you've got to be the bigger person, which just kills people. But it is. Sometimes you just got to swallow that pill. The next thing that we realised, particularly with avoidant type in this mediation negotiation phase, where they're just not, they're ignoring the offers, they're ignoring negotiations, they don't want a bar of it. Sometimes we need to just lay out not just the outcome, not just the offer, you get this, I get that, but the how is it going to happen? So you got to ask yourself, are my negotiations showing my avoidant ex how this happens? Because if someone says to you, yeah, you can buy me out of the house and this will happen and this will happen. And if they're an avoidant, particularly like I was like, I can't see how that's going to happen and that's impossible. No, I don't want that offer. So showing them how. So Mum, can you talk a little bit about that?
Yeah, showing them how it works, setting out the steps, being sort of confident about that. And even with clients of mine who were avoidant, I would say to them, this is what it's going to look like once it's settled. Can't you just see yourself in your own place with some money in the bank? You need to do that for the avoidant person because sometimes they may have struggling mental health-wise, but they may just be plain scared and stuck and impossible, and seeing it impossible. So, show them how it can be done, when it can be done, and what it'll look like for them afterwards.
So even if you have to write out a step-by-step, it doesn't have to be in your agreement, but, you need to go to the bank. You need to find out what your lending amount is. You need to see if you can afford. Give them some steps so that they know, okay, I can do that. And you kind of leading them to the solution.
I would number those steps.
Okay, Mum would number those ones. Okay.
Yeah. So it depends how avoidant and vulnerable your ex is, but sometimes certain steps to be done might help.
Because I do see so many people who are just stuck. They're stuck maybe because their ex is stuck or because they are, and they just cannot see life any different, any possibility of a life different from the one they had when they were married. And these people get stuck because and I was the same, I thought, how can I have my property settlement so that my life doesn't change at all? Like everything's the same. And that's something you've got to wrestle with yourself. But if you're negotiating with someone like that, you've got to bring them around. Because Mum, you said you talk to your clients and get them to look at properties online.
I send them, and before online, I used to send them out for the weekend and go to open houses, particularly if I had a client who was particularly fond of their house. You build your forever home and you can't see why you should leave and you can't imagine what it would look like if you leave. But I've never been in an open house that I didn't love. Because of course they've got everything styled and I go, oh yes, this is wonderful. So I pack them off and it's never failed so far with people. And I'm thinking of a few who were particularly stuck and that I had to tell them gently and with love that it wasn't going to happen. They weren't going to get the house. And if you do get the house, for instance, I said to a lot of them, I used to say, you won't have any cash. What are you going to do when the washing machine blows up?
Yeah. So you got to, hopefully a lawyer's going to be doing that for your ex, but if they're not and you're amicable or good enough, you can kind of gently bring them there yourselves. All right. Let's talk about mediation's done. It didn't work. These people are now really pulling their hair out. They're like, dang it, I don't want to have to go to court. And this is the middle stage. And we've called this turning up the heat strategically.
Mm-hmm.
So in this phase, Mum, this is when you're turning up the heat and we're talking about showing them cases, giving them legal insight and real world consequences. What kind of things in negotiations can they do to turn up the heat once all these nice, gentle things have not worked?
Haven't worked. Hopefully with the nice, gentle things, you've crystallised what exactly the arguments are. Right. And during mediation, we don't like to say it failed, remember? We like to say that it didn't conclude everything. But during mediation, you would have found out some of the arguments that they are going to make. And some of them can be like news to you. You know, when they say these outright, you think, what? So at least you know their strategy now. So the next stage, this stage of turning up the heat, involves writing slightly firmer letters, supporting it with sections of the legislation. This is a letter to them.
Yes.
So the letter doesn't contain the offer.
Yeah.
The letter tells them what will happen to them and how much it's going to hurt if they don't accept your offer, which will be in a separate letter.
So why your offer is right, basically.
That's right.
Okay.
That's right. And you're also writing to their representative, not just your ex, but you are writing to your ex as well. So what you do is for their representative, if their client's telling them rubbish, you might say, I know your client's saying this, but look, here's the documents. Your client is incorrect on these points. Do that.
And that's so that the lawyer can then give their client some hard talking to. If your ex is
reality check.
If your ex is making up lies about, I don't know, being the primary carer or lies about, I don't know, whatever.
Fantasise something, yeah.
If you can prove that to their lawyer, then they might give them a reality check, which may get them to agree to your offer. Is that what you're saying?
Yes.
Okay.
That's right.
Yep.
So you're recruiting their lawyer to talk hard truths to them.
Okay.
You're also putting in cases. I assume their lawyer knows about the cases, but I always put them in with a hyperlink so that when the letter is sent, emailed to your ex might have a look at those cases and get some reality check about the chances of how things go in court and how other people have been through similar situations and the outcomes.
So they're the other people's court cases where judges have made rulings.
Yes.
And then you read those cases and it explains why they made that ruling.
It tells you how the court thinks. They're applying the law.
So you would want to find cases that are applying to the sticking points that you guys are arguing about, basically.
That's right.
Okay.
Yeah, and everyone's sticking point's different. You might have 5 cases, you might have 3 cases. Or, for instance, you might have someone who's saying that their parents are owed money. I might just send Biltoft's case to them, to check. Okay. So, those sorts of things.
So that might knock them into going, oh, okay, well, if I go to court, then I'm actually not going to get what I ask, so maybe I should agree to their offer.
You'll never find a case just like yours, which is why I've always loved family law, because every case is different, seriously different. But you might find a case for one point you're arguing, you might find a different case for another point you're arguing, and those as a cluster go to the other side, okay?
Where do people find these cases?
Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? Then you need to go to thedivorcecourse.com.au to go to the free resources section where you can get a mediation checklist, a disclosure checklist, a word salad, read a letter like a pro checklist, and also a before you go checklist. Get ahead of the game and be organised and ready, as this handy checklist along with the accompanying episodes of the podcast will be perfect for you. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today.
Where do people find these cases?
It's on the FCFCOA website, judgments. So if you type in FCFCOA judgments, you'll see the cases that have been recently reported. So I was having a lovely read through them yesterday. It's why I don't need. I don't watch soap operas.
Yeah.
But it's really interesting because it's kind of like they're the examiners. And so when you're a lawyer, you want to see that, like every time you have a case and win, it's like you passed an exam. So I want to see the exam questions first.
Right. Gotcha.
And so you know how the judges are applying it. You know that the full courts or the appeal decisions are binding on the lower courts, you know that your judge does not want to be appealed. And so if you can come up ultimately with cases that, support your case, then you've got an obligation to tell the judge about them so they can consider them. You're just that much more confident that you're on the right foot.
Right.
And if they're arguing something really silly in the mediation, in this letter where you're doing the cases, you're talking about evidence of what has been happening during the relationship, then the consequences are also the cost issues. So you need to send a section. I always hyperlink the section on costs. It's in 114UB.
So before we get on to costs, let's just solidify what we've just talked about. It's a really good idea to kind of turn up the heat a little bit. If negotiations aren't working and you feel like you're ramming your head against a wall, you don't want to go to court, but you want to kind of make them be like, oh, okay, if she does take me or he does take me to court, this is what's going to happen. So you're bringing up comparable cases. You're, trying to get legal insight. I think it's important to note here too, sometimes people have a really hard time negotiating with their exes if they have lawyers who aren't family lawyers or they're not family accredited specialists. Because we are hearing that there are some lawyers that just have these wackadoo ideas about superannuation or just completely confused about income or a salary that people earn during the marriage matters. There's some stuff that we're seeing from our members that lawyers are trying to tell them that are not true. And so, so it's hard.
Looking at you, equalisation of super lawyers.
Yeah. So if you're trying to negotiate with your ex and your lawyer is telling them something that's not right, you kind of need to educate them as well in a subtle way. I guess you're putting those cases in. Or, Mum, one of the questions you say to ask is if they're saying, oh, this is 100% how the law is, Mum, what should people be saying to their lawyers, lawyers?
That's right. If you can't find a case that supports your contention, sometimes it's because it's well known and everyone knows it. Maybe ask their lawyer to provide the cases so you can be educated about what it is their client is claiming. Okay? And that turns the table.
Okay.
Yeah.
All right. So we've done that. We've talked about, and I guess you could bring up real world consequences. The other thing that is like the house price is going up. And
that's exactly right.
You might not be able to afford to buy this out if we leave this drag on for another year. Those kind of real world consequences.
They are. That's right. That's exactly what you can do for real world consequences.
Now, Mum, I know you're just raring to talk about costs. So that hasn't worked. Now we're at the people who are court is looming. There's temporary offers and pressure tactics going on. I guess we should probably talk about pre-action procedure letters as a way to negotiate.
Yep. So, and that brings me back to the central practice direction. When you're turning up the heat, you can also turn up the heat subtly on the lawyers as well to remind all parties about the provisions of the central practice direction. And WA has a similar one that requires the lawyers and their parties to behave sensibly and with a view to efficiently dealing with the case. And there have been cases recently, like a month ago, where the lawyer and the barrister and the client were ordered to share equally in the costs of someone's case because of their behaviour.
Right.
So lawyers are in the firing line, they're officers of the court and they have an obligation. Now, back to costs.
So you refer them to the central practice directions for those. We've got a good episode on that and the numbers if lawyers are behaving badly. So go and listen to that episode. Yes.
I've seen that work miracles.
Okay, perfect.
Just send a copy, refer them to 1.3, 1.4, and suddenly they're, oh, okay, we'll go to mediation. We'll do this, we'll do that.
Perfect. Okay. All right. So you've done that. All right.
Yes.
Now, the threat of court, is that a negotiation tactic?
Yes, it is. So you're sending your offer when you send that letter explaining why your offer is fair, right? And you have it as a separate document. Now you say to them, if I have to go to court, I'll be using this offer that I sent you in relation to costs. And that makes them think, okay, not only has your ex got to pay their legal fees, there's potential for them to have to pay your legal fees. So I would attach a copy of 114UB of the Family Law Act, capital U, capital B of the Family Law Act, that shows your ex that there's consequences. So here's what happens if you get it really wrong, right? You say you've been in mediation, your ex has been flogging a dead horse, all right, or you have been, okay, because you're not educated yet. Then they educate you or you educate them, and they should know now that they are not going to win. Sometimes that isn't enough to stop a person because they just love the fight, right? So then you explain to them that they may have to pay your legal costs as well as theirs, because a sensible person, it's scary enough having to pay your own legal fees, let alone the other person's legal fees. And so that kind of turns the heat up even more. And suddenly dragging it out for the fun of tormenting you doesn't seem as attractive as it did before.
Weighing up all that money as opposed to making you suffer.
Yes.
And sometimes they do love the money a lot more than anything else.
There are those people who cut their noses off to spite their face, as we've heard, that would rather give the money. And I've had people in my career, I'd rather give the money to you than have them have it. And you go, no. But it's the principle. You can't afford to have principles. This is the law. These are the realities. And I used to have a bookcase full of cases, Laura, behind me. And I would sweep my arm back and say, see all those books? They're full of cases where both parties thought they were right and only one of them was right and the other one was wrong. So it's a bit of a gamble going to court. So you really have to frighten them into it. Don't say indemnity costs easily, because the court's getting sick of that and it's not right, you know.
Right. So an indemnity means paying everything.
Yeah. And only very rarely, I mean, the person has to be pretty grim for the court to order that. But you look like a bully if you put indemnity costs in your application or your letters.
All right. So if you want to learn more about costs and Calderbank offers, which Mum's just talked about, we have a whole episode on that will help you. In saying that, they've moved it to a different section of the Act. What is the section now, Mum?
114UB.
Okay. So we talk about it in a different section, but it's the same principle.
So, Laura, when you put in a Calderbank offer or an offer to the other side, the court is not allowed to know about that if you go to trial. They only look at it in respect of costs. And you are able to hold your letter up, your offer up, and say, Your Honour, we are only here today because this very reasonable offer was not accepted way back in December 2025.
Right.
Okay. And so you can only do that if your offer was really good and it's the same as what you got at trial, or even your offer was worse for you than you got at trial and they still didn't accept it.
Okay.
Yeah.
So you kind of make that, and the pre-action procedure letter is saying, because in the pre-action procedures, you've got to give them 2 weeks notice before you file, unless it's urgent. So sending a letter saying, here's my offer, I'm going to go you for costs if you don't. And also, if you don't, I'm going to be taking you to court in 2 weeks. That's got to put so many rockets under their chair.
Yes.
Surely that's going to make a lot of people jump and get actionable negotiations happening.
Yep. You send that letter and you have to mean it, right? Your pre-action procedure letter sets out precisely the orders you're seeking. And I like to put a date and a time after which I will go to court, and always say without further notice to you. And you would be surprised. If I put a time, if you say by 3 p.m. or 2 p.m., the worry is that after 2 p.m., you may have all of your documents ready. They may be worried that you're just going to file it, upload it to the court at 3 o'clock and they're done. So the number of times you can always set your clock, 10 to 2, if you make a 2 p.m. deadline, the phone rings or a message comes through or an email turns up trying to negotiate, which you can then look at and say, well, was that a reasonable response? Or if it's not, if it's more of the same, then proceed with your filing.
Yeah. We do hear some people's exes who, I'm calling it breadcrumbing. I know breadcrumbing is different for relationships, but where they give them a little bit of disclosure, a little bit. Every time they kick up a stink or threaten court, they give a little bit more and a little bit more. And then they send the pre-action procedure, so they send a little bit more, but it's never fully the amount. So, Mum, I guess if they've done all of that, then they're like, you've got 2 weeks. They still haven't negotiated properly. So then you're in court. The other really nitty-gritty time that people negotiate is at the door of the court on the
Yes.
day of the trial. Is there any strategies or negotiation tactics that you would recommend for people in this phase?
It's tricky, isn't it? Because we used to all turn up at court and there were many things would settle the door of the court. In this case, when there's a lot of people attending their first court date by Zoom or by WebEx, I think the court is using now, then there's usually emails flying back and forth between the lawyers, trying to resolve as many issues as you can. You may feel pressured by your lawyer at that stage or by the judge because you might get an offer, first time you've ever seen it, and somehow you're expected to assess the offer and accept it or not in like 20 minutes before you're called back before the judge.
Yeah.
I think that's where people fall down a lot. When you go to court, it's not just whether they've given disclosure, Laura, because people, they played up. By the time you get to court, you may have a history of them cancelling mediations, dodging stuff. It's not just the disclosure. Okay, so you're giving the court their whole bad history, which is why I think they start making offers on the morning of the court or the afternoon before. Okay,
Because they don't want to go in front of the principal if they've been naughty at school. They don't want to get busted. So they're like, oh, how do I avoid being in front of a judge?
And their lawyer probably doesn't want to either, because the judges rarely get cross at the litigants in person. They direct their comments at the legal representative, so it reflects badly on them. And I think that's where people... So that's a kind of intense negotiation. And in a situation like that, I would recommend when you go to court, or if you're in a mediation where these negotiations are coming thick and fast, to have worked out some sort of little Excel spreadsheet or some little ready reckoner to say, right, if I get 120,000 plus the house, oh, that's 52.1% or 52% of the property pool. They have that ready for you. And if they put you under pressure for an offer, or there's an offer they might be considering, then your lawyers or you can ask the registrar, could you please stand the matter down for an hour while I assess this offer or while they assess my offer or something like that. And usually the court will let you do that.
And I think that's important that you do that homework before you go.
Yes.
We have a Batner and a Watner episode where you've got to consider what's your worst case scenario, what's your best case scenario, and where are you willing to draw the line. You don't want to be asking yourself that question with 20 minutes before you're in front of the judge. You want to know the answer to those. So when they do give you an offer, you can say, does that fit within my threshold that I can, that'll help you make a decision and negotiate better in that kind of intense situation.
Yes. And so does if you're hoping to keep the house, get a kind of pre-approval or get some idea of how much you can borrow. So you go in at every turn ready to assess an offer or to make an offer. Now, if they start sending offers in without supporting documents and you need a document to verify whether or not that's a good offer, I think you could tell the registrar that as well.
You can say, I can't accept it because I don't know what the disclosure is, for example.
There's a proposal on the table. I'm unable to assess it. I need this, and this. And the registrar may well order that the other person gives you those documents. But what you're doing, if you look at it, Rosie, you're starting to narrow. At every stage, we're narrowing the things in dispute. So now you're in court, and in our imaginary case, you're before the registrar, and now you're arguing over 3 or 4 documents, and then there's a proposal on the table.
Now, they're all the different stages. Now we're just going to quickly breeze through the do's and don'ts. Okay. All right. So we've got 10 of each. Some may be more important than others. Let's start with the don'ts.
Yeah.
Okay. Don't ignore their personality type. So make sure you know what they're divorced. Are they amicable, high conflict, manipulative, controlling, or avoidant? And you need to negotiate based on those strategies, based on those personalities. Don't lowball or highball offers, Mum. Why is it not a good idea to do that, like a used car negotiation?
Yes. Yeah, the stakes are too high, okay? And also the central practice direction says that ambit offers, which is like big, broad, will not be tolerated. This is too important. And also, if you do a lowball offer, you can't use that offer to get costs at the end of the case because they were quite right not to accept it. So you always have to be reasonable.
And I think it also ruins your credibility with your
does.
ex, because they'll be like, really? Come on.
And I think they don't read the next one. So and sometimes that hurts a person's feelings so much they can't negotiate with you.
This is a biggie. And Mum, you wanted this one raised. Don't make small concessions over and over and over just to keep the peace. So can you explain what that means?
Yeah. So it's a thing of a manipulative and controlling person, right? And you being a nice, kind person, and they want this, and you go, oh, fair enough, okay, have that. And but I also need, 20,000 for. Oh, here you go. And by the time they've got all that out of you, they're very comfortable. I'm not talking about starving someone out economically, but I'm talking about if there's property settlement happening, don't give them so much that they've no longer got an incentive to settle, okay? So keep stuff back.
So you basically, Mum, you're saying make one deal if you can, and
if you can.
one and done. Not because a manipulative and controlling will just try and weasel little things out of you until they've got everything they need and want anyway, and then you've got no negotiating power.
Also, too, they'll go out of time. They'll make you talk and talk and talk. You'll think you're settling, and then you're out of time on your time limits.
I've also seen this happen where they're negotiating and they say, okay, well, what about this line here? Can we change this to being a little bit more money or something?
Yes.
And the person thinking that means the whole agreement is now
finished.
sorted.
Yeah.
And so they agree to that. And then they come back and they're like, no, that's the only thing we've agreed to. Now we want to agree to all the others. So make sure that if you are negotiating one particular thing, that it's in the understanding that's the whole agreement. And once that's agreed to, then the whole agreement is agreed to.
I think a way to do it, if you're doing it, is to get that in writing if they haven't got a lawyer.
Okay.
Yeah.
All right. Don't keep giving ground without recognition, or they'll see concessions as defaults. What does that mean?
Okay. If you negotiate and say you won't touch their super, for instance, all right? I'm not going to touch the super. And then you get some advice and you think, you know what, really I have to take some super. Or I have to give them some super. To them, that's a betrayal. You already agreed on this. Now you're backtracking. And again, it's hard for them to get over the hurt and the misunderstanding or whatever it is that they've had with that. So be careful. I'm not talking about those ones, remember, when in the very early stages and it's probably genuine from you or it's to get out of the place safely. I'm talking about in writing and when you're in the serious negotiations, because they will just take that concession, put it in the back pocket and work on the rest.
Yeah. It's very hard to negotiate backwards if you've already agreed to something, is basically what you're saying. Yeah.
It is. And their lawyers should have a go at them about it and say, well, what's changed?
Okay. All right. Don't let them get too comfortable thinking the deal already favours them. They'll stop engaging. So in negotiations, we talk about the divorce dynamic as well, balancing power with progress. And we see a lot of people, we call them sitting pretty. They're in the house, everything's being paid, they're happy, their life is how they want it to be, and some poor person's living in a flat or on their sister's couch. Yes. And they're the ones that are desperate to get property settlement. The other people are like, whatever, it's fine.
Yeah. And from the point of view of the person who's in the house, assuming they have to borrow to pay you out, that means they are going to have a bigger mortgage from the day they pay you out. So they've got no incentive to settle. Also, sometimes everything that they want is already in their name. And so if nothing happened, if the deadline, if your time limits elapse and you can't get permission to go to court, everything stays in whose name it is. And again, that makes them comfortable, sitting pretty, and you're the one frantically trying to G them up.
Yeah.
And you'll be more likely to have to go to court to get them out to move because there's no incentive for negotiation.
Next one, don't give ultimatums too soon or you're going to lock yourself into rigid positions. So like you said, Mum, threatening court, you've got to really mean it.
Yeah. If you give a deadline, I say reserve that deadline for the notice of intention to file. Give that time and a day. Don't say 7 business days or 10 days. Give a date and a time. And if you can even sounds ridiculous, but it'll be like Wednesday, the 4th of December at 2 p.m. That way it's clear to everybody this is the deadline. Only do that then. I'm not a fan of people putting offers to the other person and saying, this offer only lasts for 14 days, you can't then use that letter for your costs usually going further down the track, particularly if they write back and go, I need more information. So I think you need to keep an offer going pretty well all the time. You can withdraw and replace it with something, but I would suggest offers all the time. Keep your deadlines. As a lawyer, of course, everyone knows that if I used to say I was going to do this at a certain time, I made sure I did it. I never let my clients try to get me to bluff because you lose your power.
Right. Don't negotiate to make a point. Negotiating to reach practical, try to negotiate to get an outcome. So we hear about this a lot with manipulative controlling, definitely high conflict, or people that are just hurt, like really, really bad things happen to cause breakups. And so people are just hurt and they're acting out of pain.
Yep.
And some people are just acting out of, they're just horrible humans. So negotiating to make a point, does it ever work, Mum?
I don't think so. I think you have to try and lift yourself out of that mood. I think a lot of disclosure arguments can be about making a point or proving perhaps that your ex is spending money that you don't think they should on unwise choices and stuff like that.
Your girlfriends.
It's Christmas, and I know you don't like this analogy, but honestly, do you remember the Mr. Bean episode where he had a nativity scene in a shop window and a Dalek was going around exterminating? And he had a toy helicopter he lowered down and he winched everyone out so they were safe. You are winching yourself out, okay? Leave them with their mess and whatever it is that's going on, and you're just going to focus on what does it take to get you out of that situation and safe.
Okay, that is the most bizarre analogy I've ever heard for divorce, the Mr. Bean Christmas nativity scenes. Go and Google it. It's actually kind of funny.
It is.
Okay, but yeah, you're getting yourself out. Don't bother making points with these people.
No.
If they haven't seen the error of their ways in your marriage or in your relationship, they're not going to see the error of their ways through negotiations either. So
to paraphrase Mel Robbins, let them.
Yeah.
And your friends and family will work out for themselves what they're dealing with.
Number 9, don't ignore your own needs.
That's right. Yeah. Don't ignore your own needs. So it may be that you don't have enough money to live on from week to week. Maybe that when you get the property settlement, you're going to spend more than half of it on school fees or something else. So just have a good look at yourself. Treat yourself like you would a dear friend, and make sure that you're not being sold down the river for stuff.
Look at what you need, because I do hear people feeling bad they've left, or maybe they've done something horrible. They feel bad, so I just want to give it all to my ex. Or I want to do whatever they want. But really, one of the best exercises you can do is sit down and write out, what are you going to need moving forwards?
Yes.
And is that going to be included? All right, and the last one for don'ts is don't think that it's the end of the world if you get a no.
That's right. It's just no, not yet.
Right. And there are, as we've just talked about, all those different ways and all those different strategies you can try. And so they may come back and say no to start with, but they can actually come back and say no the whole way through. They can say no even after you've got your orders because a judge can do it.
Yes. And they sometimes do, but. Yes.
Yeah.
But the ultimate decision maker, of course, is the judge. But such a low percentage of cases ever need a judge's decision.
Yeah. So you will get there. So don't despair. Now, to be positive, we're going to go through some do's, okay? So we've talked about them already, but I'm just going to touch on them. Do try to repackage your offer to make it more appealing. Presentation matters. Think about how you're numbering it. Think about not using numbers. Think about what's at the top, what's at the bottom. Really think about it. Do speak their language. Try and use their terminology. Try and use their formatting. Do explain the how, not just the outcome, so that they can actually see it's realistic and that can actually achieve it, so they can say yes. Do consider their personality type. I guess that's the opposite is don't. Because the way you communicate and the way you engage with them is going to differ based on who they are and what their motivation is. You need to think about their motivation.
Yeah.
Do think about their real interest. So what are they actually caring about? If you don't know that, if you don't know what really is the crux of everything for them, if you haven't thought about it, your negotiations aren't going to work as well.
And it might be like they're they really might want to keep their Maserati or their aeroplane, or they may really care how the church views them, you know?
Yeah.
So have a think about those things.
Was it with parenting? I think Mia, in one of our narcissistic co-parenting ones, she said sometimes when you're negotiating custody and things, I think she said, like, they care about what they look like to the outside
Yes.
world. If you know that, then you can say, all right, I'll have the kids the majority of the time, but you can take them to sport because that's where people will see them. You know, you can let them do those things if that's going to get an agreement where you've got the kids the whole time. Like, you know, these are the things you need to think about. All right. Do use examples of case law to anchor your offer in logic.
Yes.
Do present temporary offer strategically, especially if court's approaching. Do use tools like Calderbank offers or cost threats to apply pressure without hostility.
Yes.
I don't know how that you do that without hostility, but it is what it is.
Fair but firm.
And do remember that negotiating isn't about punishing. It's about avoiding court, gaining certainty, and finalising things for everyone's benefit. And do your homework before you make any offer, because you don't want to make an offer that you don't end up actually wanting.
Yes, you don't want to make an offer they accept and you're sort of miserable with it.
Yes.
And the same thing, you don't want to make an offer that's so absurd and high for you that you can't use it for cost arguments later on.
Perfect. Now, that's a lot. I
It is.
know it's a stressful time for everyone, and negotiating, it's just an ongoing, monotonous process that sometimes can feel like you're being dragged through or you're dragging them through it. But there are these strategies you can put in place, and if you actually think about it, even if you've got a lawyer, you do the thinking. You go to your lawyer and say, hey, I think this is their motivation. I think this is what they're stuck on. You know, have a little think about these things and educate your lawyer on your ex. You're the expert on them.
Yes.
Mum, what would you embroider on a cushion?
It's no means not yet.
Okay. No means not yet. So I know we're at the, if you're listening to this when it comes out, we're at the pointy end of the year. We're getting into the, you know, the holiday festivity seasons. And if you haven't got an agreement yet, it's a really hard time to have everything up in the air. And we know the feeling. Mum and I both know the feeling.
We do.
So we're here for you. Go and listen to some of our holiday ones if you need some support around that, particularly with kids. That can be really hard as well. But don't give up. Make sure you give yourself a break as well, if you can. And we will be here for you. And let us know in the comments what negotiation strategies you didn't know about or that you are working on. And let us know in the comments. Thank you so much, Mum, for your time.
No worries, Laura.
And good
Thank
luck,
you,
everyone.
everyone.
We'll see you all next week.
Bye, Laura.
Bye, Mum.
Bye, everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general only and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.